I don't know if my Lord is hearing me.
Yes, let me take your appearances, please.
Stop please. May it please the honorable court, Aduojo Abba, my
Yes.
lord, appear with my learned friend, Chinedu Beahurike. Our appearance, my lord, is for the claimants, my lord. We are grateful, sir.
Thank you.
My lord,
Yes.
E. Otrofanowe.
Yes.
My learned friend, A.O. Ishokare appears with me for the defendant. See that.
Thank you. This is the court's decision.
Stop please, sir.
The network in Yenagoa has not been friendly, so we'll see how we can manage it.
Stop please, sir.
Visit.
The claimant commences suit by way of complaint and statement of facts filed on the 17th of April 2018, and with the leave of court granted on the 25th day of October 2022, the claimant filed an amended complaint and an amended statement of facts on the 22nd day of November 2022 and claims the following reliefs against the defendant. 1, a declaration that the employment of the claimant's members in the defendant is regulated by the Delta State Oil Producing Areas Development Commission, the SOPADEC Staff Condition of Service, 2012. 2, a declaration that the defendant is bound by the terms of the Delta State Oil Producing Areas Development Commission, the SOPADEC Staff Condition of Service, 2012. 3, a declaration that the refusal of the defendant to grant audience to the claimant to address issues of workers' welfare constitute unfair labor practice and offense international best practice. 4, a declaration that the queries, transfers, and suspension of claimants' members on ground of their union activities is unlawful, constitute unfair labor practice, and offense international best practice. 5, an order compelling the defendant to pay forthwith the claimant's members' end-of-year allowance for 2016, 2017, 2018, 2019, 2020, and 2021 in the manner provided in Chapter 3, Clause 3.6.1 of the Delta State Oil Producing Areas Development Commission, the SOPADEC Staff Condition of Service, 2012. 6, an order compelling the defendant to pay arrears of 30% of salaries for members of the claimant who were owed same since July 2009 to April 2018 forthwith. 7, an order of perpetual injunction restraining the defendant from further deducting and withholding 30% of salaries of members of the claimant from May 2018 as being contrary to the terms of their contract and extant labor laws in Nigeria. 8, an order compelling the defendant to implement the medical benefit package in the manner enshrined in Chapter 3, Clause 3.4.1 of the Delta State Oil Producing Areas Development Commission, the Supervised Staff Condition of Service 2012 forthwith. 9, an order compelling the defendant to promote all the members of the claimant in line with the provisions of Chapter 2, Clause 2.15 of the Delta State Oil Producing Areas Development Commission, the SOPADEC Staff Condition of Service 2012 forthwith. 10, an order setting aside the queries and suspension issued to claimants members as a result of their union activities for being unlawful, unfair labor practice, and offensive to international best practice. 11, an order of perpetual injunction restraining the defendant from transferring, suspending, victimizing, and punishing members of the claimant on ground of their union activities. 12, an order directing the defendant to deduct checkoff dues of 3% from monthly basic salary of each staff that are members of the claimant and remit same forthwith to the claimant. And 13, cause of this action. The defendant who initially filed a statement of defense on the 13th of September 2018, however, relied on the amended statement of defense filed on the 17th day of January 2023. The claimant filed a reply to the amended statement of defense on the 7th day of March 2023, which was regularized on the 17th day of May 2023. Trial in this suit commenced de novo on the 4th day of February 2025, when the claimant called the subpoena witness, Gabriel Yenagoa, the Deputy Director and Director of Legal Services of the defendant, who testified as CW1. In compliance with the court subpoena to set take-home, the witness produced the document listed as number 17 on the subpoena, which is the CTC of the circular reference DES/DEPT/4/AS/250/119 dated 9th of August 2018, which was admitted by the court as Exhibit CW1A. The witness informed the court that the defendant does not have the other documents because they were either addressed to individual members of the board whose appointments were tenured, or they have been misplaced due to movements of offices. That the document listed as number 39 on the list does not exist at all because no document usually accompanies the monthly allocation to the accounts of the defendant from the State Accountant General. The claimant then called her second witness, Comrade Solomon Obomaga, who identified and adopted his witness statement on oath filed on the 22nd day of November 2022, and also the additional deposition he filed on the 7th day of March 2023. The following documents were tendered by the claimant and admitted by the court. The staff condition of service of the SOPADEC 2012 Exhibit CW001. The SOPADEC letter dated 2nd November 2017, Exhibit CW002. The SOPADEC letter dated 11th October 2017, Exhibit CW003. The SOPADEC letter dated 6th of February 2018, Exhibit CW004. The SOPADEC letter dated 26th of February 2018, Exhibit CW005. The SOPADEC letter dated 26th. The solicitor's letter CW007. The solicitor's Exhibit CW010. The claimant's letter dated 9th of November 2017, Exhibit CW011. The claimant's letter on request for the deduction of checkoff dues / dues of staff of grade level 01 to 06, Exhibit CW012. The claimant's letter dated 21st of May 2018, Exhibit CW013. The claimant's letter dated 9th of November 2017, Exhibit CW014. The claimant's letter dated 24th of August 2018, Exhibit CW015. The claimant's letter dated 21st of May 2018, Exhibit CW016. The claimant's letter dated 13th of October 2017, Exhibit CW017. The claimant's letter dated 20th December 2017, Exhibit CW018. The claimant's letter dated 6th of February 2018, Exhibit CW019. The claimant's letter dated 28th of November 2017, Exhibit CW020. The claimant's letter dated 17th of October 2017, Exhibit CW021. The claimant's letter dated 3rd of October 2017, Exhibit CW022. The claimant's letter dated 22nd of February 2018, Exhibit CW023. The claimant's letter dated 14th of February 2018, Exhibit CW024. The claimant's constitution, April 2013, Exhibit CW025. The claimant's letter dated 17th of January 2019, Exhibit CW026. The SOPADEC board resolution dated 19th of December 2014, Exhibit CW027. The SOPADEC board resolution dated 14th of October 2009, Exhibit CW028. The SOPADEC letter dated 28th of April 2017, Exhibit CW029. The SOPADEC letter dated 2nd of November 2017, Exhibit CW030. And the SOPADEC letter dated 11th of October 2017, Exhibit CW031. The witness was cross-examined by the learned counsel to the defendant, E. Otrofanowe, before being discharged without any re-examination on the 17th of October 2025. The claimant closed her case on the same 17th day of October 2025. The defendant opened her defense on the 17th of October 2025 by calling her sole witness, Akparobi Precious Ogalomino, an employee of the defendant, who gave evidence as DW. The witness affirmed to speak the truth and then identified and adopted her witness statement on oath, which was made on the 17th of January 2023. The following documents were tendered by the defendant through DW and admitted by the court. Bundle of CTC of official receipts, Exhibit DW1. The defendant's circular dated 19th of September 2018, signed by Ogenocho of Wayne Joe, head HRM, Exhibit DW2. The offer of appointment in the name of Oza Azuka Donatus, dated 6th of May 2011, Exhibit DW3. The offer of appointment in the name of Esoro Isaac O, dated 6th of May 2011, Exhibit DW4. Evaye Austin, dated 6th letter of 5th of March 2018, addressed to the Honorable Commissioner, Ministry of Transport, Asaba, Exhibit DW6. The bundle of documents comprising of query and suspension letters, Exhibit DW7. The circular dated 16th of November 2016, signed by Obogon P.O., Acting Director, Administration and Supplies, Exhibit DW8. The report of committee on the SOPADEC medical bills from November 2007 to May 2009, submitted to the board on 28th of July 2009, Exhibit DW9. The bundle of documents which are offers of appointment in the names of Ejabolo Evaye Austin, Oluba James Bode, Oza Azuka Donatus, Etsero Isaac O, and Magege Matthew, Exhibit DW10. The bundle of documents comprising of application for financial assistance dated 20th February 2020 and medical reports were admitted as Exhibit DW11. The offer of appointment in the name of Magege Matthew, Exhibit DW12. The list of lawyers in the Sopade posted to Ministry of Justice and PPEB, Exhibit DW13. The Sopade memo dated 9th of August 2018, Exhibit DW14. The offer of appointment in the name of Oluba James Bode, Exhibit DW15. And the bid for a law to repeal the defendant's law was admitted as Exhibit DW16. The witness was cross-examined by the Learned Claimants Counsel, Adejo Abba, before being discharged without any re-examination. The defendant closed her case on the 17th day of October 2025. With the conclusion of evidence in the suit, the parties were ordered to file their final written addresses, while the defendant's final written address was filed on the 12th day of November 2025, but regularized on the 11th day of December 2025. The final written address of the claimant was filed on the 9th day of December 2025. The defendant filed a reply on points of law on the 15th day of December 2025. These court processes were adopted by both Learned Counsel on the 21st day of January 2026, with CN Ngbeahurike appearing for the claimant, while E. Otrofanowe appeared with EL Otrofanowe Mrs. for the defendant. Now, the case of the claimant. The claimant pleaded that as a trade union, it has the powers to defend and protect the rights of its members in the employment of the defendant. That while the defendant's condition of service, which regulates the employment of the defendant, provides in clause 3.6.1 that every staff who works for 12 months is entitled to end-of-year allowance. The members of the claimant who work for 12 months in 2016, 2017, 2018, 2019, 2020, and 2021 have not been paid their end-of-year allowance for those years. It was also pleaded that by the defendant's board resolution of 14th of October 2009, the defendant resolved to pay salary of the claimant's members less 30% for the months of July, August, and September 2009, with a promise to pay the remaining 30% in the month of October 2009. And sequel to the resolution, the workers were paid only 70% of their salaries for the months of July, August, and September 2009. That rather than paying the balance of 30% as promised, the defendant continued to pay only 70% of the salaries till date, and therefore owes the claimant's members arrears of 30% salaries from July 2009 till date. The defendant has also refused to provide medical benefit as provided in clause 3.4.1 of the condition of service, and also refused to promote the staff every 2 years as provided in clause 2.15 of the condition of service from 2011 till date. According to the claimant, because of the disharmony in the workplace, due to the defendant's refusal to pay the end-of-year allowance, 30% salary arrears, medical benefit, and refusal to promote the staff, the claimant sought audience with the defendant sometime in October and November 2017, but the defendant refused to meet with the claimant, which led to the protest by members of the claimant. That while the members of the claimant were peacefully protesting on the 8th of January 2018, the defendant invited the police and hoodlums to attack them, and several persons were thoroughly beaten, tear gas, and injured. The defendant then constituted a committee sometime in February 2018, which selectively invited some active members of the claimant to appear before the disciplinary committee. According to the claimant, 7 members of the claimant were suspended from work without pay, ostensibly because of their involvement in trade union activities. That even when the national officers of the claimant sought to meet with the defendant in February 2018, the defendant refused to meet with them. That the defendant has hatched a plan to transfer key members of the claimant, which made the claimant to give a pre-action notice to the defendant on the 1st of March 2018. That even though the defendant is under obligation to deduct check-off dues of 3% of monthly basic salary from each staff that are members of the claimant and remits them to the claimant, the defendant has refused to deduct check-off dues despite several demand letters to that effect. That unless the court intervenes, the action of the defendant may snowball into a major crisis in the oil-producing areas of Delta State, whose ethnic nationalities are members of the claimant working in the defendant, thereby defeating the purpose of setting up the defendant, which is to bring development to the oil-producing communities and to reduce youth restiveness and create peace in the state. Now, defendant's case. According to the defendant, his role goes beyond employment of staff and payment of salaries, but majorly covers infrastructure and human capital development of all producing communities in the state, which it does by constructing roads, bridges, public infrastructure, such as schools, hospitals, among others, from the resources released to it. That apart from the condition of service, his relationship with his staff is also regulated by the circulars amending the condition of service, as the provisions of the condition of service were derived from the public service rules, the financial regulations, the Civil Service Commission regulations, and the scheme of service. That while it is true that initially workers were paid end-of-year allowance without recourse to what was obtainable in other state government agencies, commissions, ministries, etc., and that the salaries of the members of the claimant were reviewed downward by 30% based on the agreement with the representatives of the workers. Of the 5 ethnic nationalities, the claimant's members are, however, not entitled to end-of-year allowance for 2016 to 2021, and the defendant did not approve such allowance for 2014 as alleged. That by the defendant's condition of service, salaries and allowances are fixed and determined by the Commission, subject to the conditions prevailing in the public service of the Federation. And when salaries and allowances were reviewed in 2016/2017, the defendant discovered that the end-of-year allowance hitherto paid to workers in the Commission was outside the condition of service prevailing in the civil service. The defendant pleads further that while by the establishment guidelines, the defendant was to engage only 300 staff, over 4,000 staff were, however, engaged outrageously. That due to dwindling resources arising from oil prices and fluctuating output, the defendant had to review his workforce, salaries and allowances, and also the monthly impress for the running of each department or unit was reduced by 75%. That in order to avoid workers being thrown into the labor market, the management of the defendant met with representatives of the workers from the 5 ethnic nationalities, and it was unanimously agreed that salaries will be reviewed or restructured to bring them in line with the public service. The defendant then conducted an interview and verification of all the staff and issued formal letters of appointment with retrospective effect stating their salaries, which they accepted. That due to paucity of funds and the fact that the end-of-year bonus was not in consonance with the civil service rules, the defendant was forced to terminate same. That promotion is dependent on performance, existence of vacancy, and experience, as well as length of service and competence, and is therefore not a right. And due to the harsh economic situation, the defendant has not declared any vacancy. that while the condition of service has provisions for medical treatment, owing to the abuse by the staff, they were directed to make use of the defendant's medical center and sick bay or government hospitals upon referral by the medical center. That the letter requesting for a meeting was dropped in the office when the addressee was absent, and upon his return, the suggested date had passed. The letter was returned, but the claimant took no step to reschedule the meeting. That during the protest, the defendant explains his stance to the workers' representatives, who subsequently called off the protest, and the claimant did not have members in the defendant's service that went on strike, which led to any suspension. According to the defendant, in the course of the protest, some staff embarked on criminal activities of blocking the road, assaulting staff, and generally causing breach of peace along the Warri-Sapele Road, thereby denying senior staff, management, and board members access to the defendant's premises. That the disruption attracted the police, who intervened to restore peace and secure lives and properties, and the defendant did not invite the police. That due to chronic misconduct by some of the staff, disciplinary action was taken against them, and after fair hearing, those found guilty were suspended in accordance with the condition of service. That the defendant is within his right to transfer any worker to any of its locations for cause of advancing his services to the public, and same is not an anti-worker policy or to decimate the trade union. That the defendant is not refusing to deduct check-off dues because the process for unionization of junior or senior staff of the defendant is ongoing, and no check-off dues can be paid to the claimant who is still proposing or planning to unionize the defendant's junior staff. That the suit is therefore vexatious, an abuse of court process, and incompetent. Now, defendant's submissions. The learned counsel to the defendant submitted this sole issue for determination. That is, whether the claimant is on the evidence-led entitled to the relief sought, the reliefs claimed. It was submitted on the loan issue that since some of the reliefs in the suit are declaratory in nature, the onus is on the claimant to prove entitlement to the claims by evidence, and he must rely on the strength of his case and not the weakness of the defense. Counsel relied on Okereke against Umahi and Ogboru against Okowa. Citations are supplied. That an order for injunction is not granted just for the asking, but the party must show evidence of the existence of legal rights sought to be protected, the breach thereof, and the threat to continue its breach. On this, counsel referred to Khan International Development Limited against Little Akons Donkey Projects Limited and another. Citation is supplied. It was further posited that to determine the conditions of service regulating the contract of employment between the parties, recourse must be had to just Exhibit CW1, not just to Exhibit CW1, but also all the circulars issued by the defendant relating to the terms and conditions of work, and also the letters of employment. That the claimant failed to plead and tender any employment letter in the suit, and since the primary contract is not before the court, the claimant has failed to prove the terms of the contract. The failure to plead and tender any employment letter is fatal to the suit, relying on the case of Union Bank against Chinyere. Citation is supplied. That in construing the terms of a contract of employment, a court is bound to look at the contract of employment, and where reference is made to other documents, the court is bound to look at all of them, relying on the cases of Attorney General of Kaduna State against Atta and Leyland Nigeria Limited against Dizengoff, West Africa. Citations are also supplied. That the defendant tendered some of the employment letters as Exhibit DW10, which spells out the essential terms of the contracts, and the careful consideration of Exhibit CW1 and DW10 will show that the condition of service of staff is regulated by the condition of service Exhibit CW1, other rules and regulations in force, circular made pursuant to clause 1.1 of Exhibit CW1, and the letters of employment Exhibit DW10, that to be entitled to reliefs 4, 5, and 6 in the suit, the claimants must prove by cogent evidence that their members were queried, transferred, and suspended on grounds of trade union activities, because under clauses 2.7, 2.8, and 4.3 of Exhibit CW001, the defendant has power and legal right to query, transfer, and suspend staff when they find a need to do so. The power to transfer or post staff is a vested right of the employer and cannot be challenged or taken away, relying on the cases of Imonike against Union Bank PSC and Takim Achu against Civil Service Commission of Cross River State and another. Citations are also supplied. That since CW2 admitted during cross-examination that under Exhibit CW001, the defendant has power to query and discipline staff, the onus is therefore on the claimant to show the wrongful exercise of the power, which it failed to do. Counsel referred to Benue Cement Company against Peter. Citation is supplied. That what is admitted needs no further proof, referring to the case of Irequita against Federal Mortgage Finance Limited. Citation is also supplied. And also section 123 of the Evidence Act. That the claimant failed to call any of the staff queried or transferred to testify in the suit, even when CW2 confirmed he was not among the staff queried, and that they are still alive and still in the employment of the defendant. It was further argued that what constitutes unfair labor practice or international best practice is not a matter of speculation, but matters to be pleaded and proved. That the claimant did not plead fair labor practice or international best practice as it relates to query, transfer, or suspension. That a contract of employment is regulated by the terms of the contract and not any other extraneous matters, referring to Ibama against SPDC and Ararome Rubber Estates Limited against Orogun. Citations are also supplied. With respect to Relief 9, relating to the promotion of the members of the claimant, the learned counsel to the defendant reproduced the provisions of clause 2.15 of Exhibit CW1 and argued that for a staff to be considered for promotion, the following must be taken into consideration. The staff must have spent minimum of 2 years for salary grade level 01 to 06, 3 years for salary grade level 07 to 14, and 4 years for salary grade level 15 to 17. Performance, existence of vacancy, and experience and length of service or maturity. The claimants must therefore prove that it has members who have distinguished themselves in performance. There is existence of vacancy. They have the necessary experience and have put in the length of service and have the maturity to occupy the positions. That the allegation that the defendant has not promoted his staff is untrue, because CW2 admitted that some staff were promoted and he has enjoyed 1 promotion. With respect to Relief 8, with respect to medical benefits, it was submitted that the onus is on the claimant to prove that the defendant has refused to implement the provision of clause 3.4.1 of the condition of service relating to medical benefits, but it failed to do so. That to sustain the claim, evidence must be elicited from staff who visited the clinic or submitted receipts for reimbursement and never received treatment or not reimbursed. That the defendant, on the other hand, provided evidence to show that he took steps to check abuse of his medical provisions, and Exhibits DW9 and DW11 are evidence of the payment he made to staff for medical treatment received. On Reliefs 5, 6, and 7, for end-of-year bonus or allowance, arrears of 30% salaries, and a perpetual injunction restraining the defendant from further deducting and withholding 30% of salaries of members of the claimant, it was posited that while clause 3.6.1 of Exhibit CW001 provides for end-of-year bonus, the contract of service is regulated by both CW001 circulars and other rules and regulations for the time being in force. that Exhibit DW8, dated 16th of November 2013, the payment of end-of-year bonus was stopped, effective 2016. Learned Counsel reproduced the provisions of Section 14 of the Defendant's Enabling Law and posited that the board of the defendant has power to regulate and pay staff such remuneration and allowances as considered appropriate, that the payment of emoluments and bonuses are therefore within the exclusive powers of the board of the defendant. With respect to Relief 3, for a declaration that the refusal of the defendant to grant audience to the claimant constitutes an unfair labor practice and offends international best practice, it was submitted that the onus is on the claimant to show that it has members in the employment of the defendant and that they communicated that their decision to meet with the defendant, that it has not been shown that Exhibit CW26 was received by the defendant, that there is no evidence of membership of the claimant by any staff of the defendant, there is no membership card, no proof of payment of membership dues, and the purported constitution of the claimant was not signed, that an unsigned document has no legal effect, that cause is not granted to a party who fails to prove his case, and since the claimant failed to prove the declaratory reliefs and the injunctive reliefs, it is not entitled to cost. The court was urged to dismiss the suit. Now, claimant's submissions. The Learned Counsel to the claimant submitted this single issue for the court's determination, whether having regard to the state of pleadings and the evidence led in this case, the claimant has sufficiently proved his case to be entitled to the relief claim in this suit. It was submitted on the loan issue that the issues in dispute in the suit relate to the implementation of specific terms of the condition of service, Exhibit CW001, and not the terms in the various letters of employment of members of the claimant. Hence, the relevant document for the determination of the reliefs in the suit is the condition of service, Exhibit CW001, and not the letters of employment. With respect to reliefs 1 and 2, it was posited that the employments of the members of the claimant are regulated by the condition of service, Exhibit CW001, which was submitted by the defendant in paragraph 3 of the amended statement of defense, that the employment of the defendant is regulated by Exhibit CW001. That there is therefore no dispute between the parties on the existence of Exhibit CW001, as facts admitted need no further proof, relying on the case of Kanu against the government of Adamawa State and others. Citation is supplied. That the condition of service is the backbone of employment contract between the employer and the employee, and it defines the operational framework, safeguards the rights, and provides a clear basis for accountability and dispute resolution under the contract. The condition of service is binding on the employer and the employee, and none can deviate from the terms expressed therein. Counsel referred to Ovevie and others against Delta Steel Company Limited. Citation is supplied. According to the claimant's counsel, since the defendant argued that other rules in force regulate employment in the defendant is required to place such other rules before the court. The failure to produce the other rules in force that also regulate the employment of the claimant's members only gives room for speculation, and courts are not allowed to speculate, relying on the case of Amosun against PDP and others. Citation is supplied. That while the condition of service may be amended, such amendment must be mutually agreed by the employer and the employee before any circular to that effect can be issued, and the party cannot unilaterally amend the terms in the condition of service. That there was no agreement to amend Exhibit CW001, and no terms of Exhibit CW001 was amended. With respect to Relief 5, relating to payment of end-of-year allowance in line with Chapter 3, Clause 3.6.1 of Exhibit CW001, it was submitted that the defendant paid end-of-year bonus or 13th month salary in the years 2014 and 2015, but failed to pay the allowance for 2016 to 2024 and also 2025, contrary to the provisions of Chapter 3.6.1 of Exhibit CW001, that the defendant's argument that the end of year payment was made in the past but stopped because it is not paid by other government agencies, ministries, and commissions in Delta State is contrary to the express terms in the contract of employment, and therefore an attempt to import terms not contemplated into the contract between the parties. That Exhibit DW8, which the defendant contends has been amended, has amended Exhibit CW001, is a circular from Acting Director, Administration and Supplies to all staff that he or she was directed to inform staff that management had decided to stop payment of end-of-year bonus effective 2016 on the grounds of economic recession, and that the bonus is a mere privilege. That from the face of the circular, it did not amend Exhibit CW001, and no reference was made to Exhibit CW001 in Exhibit DW8. And the said Exhibit DW8 is a directive by the management that does not have the powers to make such directive. The court was urged to discountenance all the arguments of the defendant and direct the defendant to immediately compute and pay the claimant's members their end-of-year allowance for the years 2016, 2017, 2018, 2019, 2020, 2021, 2022, 2023, 2024, and 2025, which have been due and payable pursuant to Chapter 3.6.1 of Exhibit CW001. On Relief 6 and 7, relating to 30% salary arrears, it was posited that Exhibit CW028 clearly sets out the intention of the board and the agreement of the staff with respect to the 30% reduction in the salary for the months of July, August, and September 2009. That even Exhibit DW10 relied upon by the defendant, that same having been accepted, the members of the claimant are no longer allowed to demand for the 30% salaries deducted reflected the sum less 30% and was made to take retrospective effect from 5th of January 2009. This means that whatever right that was in existence between 5th of January 2009 and 11th of May 2011 is saved and remain enforceable. That the claimant does not need to pray for the alternative relief before this honorable court can grant the arrears of 30% salaries deducted from July 2009 to May 2011, as the court is vested with powers to grant reliefs not claimed, where after evaluation of the evidence, such relief is deserving in the overall interest of justice. On this, counsel referred to Adegboye against UBA, citation is supplied, that the appointment letters of 11th of May 2011 preserve all the rights that accrued before the issuance of the letters, including the indebtedness of the defendant to its workers, as set out in the Exhibit CW028. With respect to Relief 8, relating to the medical benefits for staff of the defendant, as provided in Chapter 3, Clause 3.4.1 of Exhibit CW001, it was submitted that the defendant admitted the claim in paragraph 8 of the statement of defense, but only alleged that there was an abuse of the medical benefit which made the defendant to stop the implementation. That the defendant who has the wherewithal to stop any abuse of the medical benefit should not abdicate its responsibility on a flimsy excuse of abuse. On Relief 9, relating to promotion of staff, as provided in Chapter 2, Clause 2.15 of Exhibit CW001, it was argued that while the minimum number of years an officer can spend before being considered for promotion is 2 years, the defendant has refused to consider the members of the claimant for promotion since 2011. That during the pendency of this case, the defendant invited staff for promotion interview, but the process turned out to be for political consideration for loyalists, and staff that were overdue for promotion were not considered, the court was urged to grant the relief. With respect to reliefs 3, 4, and 11, it was submitted that the attitude of the defendant in maintaining hostile attitude towards the claimant as a trade union and refusing to grant audience to the claimant to deliberate on staff welfare and issues relating to breach of the terms of the condition of service constitutes an unfair labor practice and offends international best practices. That from Exhibit CW 022, CW 11, CW 18, CW 20, CW 24, CW 9, CW 16, CW 004, CW 006, CW 007, CW 005, CW 17, CW 21, CW 003, and CW 002. The defendant refused to grant audience to the claimant and also refused to deduct checkoff dues for remittance to the claimant as required under Section 17 of the Trade Unions Act as amended, all in the bid to frustrate the claimant from unionizing its workers and to continue to treat the workers unfairly. That the right to belong to a trade union is guaranteed in Section 40 of the Constitution, and the employer is forbidden from victimizing its workers on the ground of membership of trade union of their choice by virtue of Section 12 of the Trade Unions Act, of the Trade Unions Amendment Act. It is therefore an unfair labor practice to be hostile to a trade union, as in the instance case, relying on the case of Pilgrims Africa Limited against Anthony, citation is supplied, that the defendant's acts of allegedly mobilizing attacks on workers during peaceful protests, suspension, and transfer of claimants members outside the mandate areas of the defendant on ground of trade union activities, despite the order of court made on the 14th of December 2018 for the parties to maintain status quo, or constitute unfair labor practice and also offend international best practice. That the defendant has a duty to create an atmosphere for the operation of trade unions in the defendant. On relief 12, for an order of court directing the defendant to deduct checkoff dues of 3% from monthly salary of each staff that are members of the claimant, it was argued that the claimant, being the trade union, is entitled to checkoff dues as provided in Section 17 of the Trade Unions Act, that the defendant recognized the claimant since 2017, but refused to deduct checkoff dues from the salaries of its workers for onward remittance to the claimant, despite several demands, as evident in Exhibit CW 12, CW 17, CW 21, and CW 11. That the documents requested by the defendant were supplied, as evident in Exhibit CW 3 and CW 2, but the defendant still refused to deduct the checkoff dues. This is to deny the right of the workers, contrary to Article 2 of the ILO Convention 29, and Section 40 of the Constitution as amended. That the contention of the defendant that the claimant does not have members in the defendant is akin to the arguments in the notice of real objection, which was heard and determined by this honorable court, where the court held that the claimant is a recognized trade union in the defendant and has local standing to maintain the action to protect and enforce the right of its members in the defendant. That by Exhibit CW 029, dated 28th of April 2017, and Exhibit CW 005, dated 26th of February 2018, the defendant recognized the claimant as a trade union in the defendant since 2017. The court was urged to hold that the failure to deduct checkoff dues by the defendant constitutes unfair labor practice and also offends international best practice in labor. The court was finally urged to resolve the loan issue in favor of the claimant and grant all the reliefs in the suit. Now, defendants reply on points of law. It is apposite to note that the defendant filed a reply on points of law on the 15th day of December 2025. With respect to the claimant's submissions, at paragraph 4.3 to 4.5 of the claimant's address, that there is no need to tender the letters of employment it was replied that the letter of employment is the primary document upon which other documents stand and must be tendered in evidence. Counsel relied on the cases of Ubok against Federal Polytechnic Bauchi, Organ against Nigeria Liquefied Natural Gas Limited, and KSJSC against Tolani. Citations are supplied. On the claimant's submission that the promotion exercise was done by the defendant with political consideration for loyalists and those with political affiliation or those loyal to members of the board of the defendant, it was replied that the address of counsel is not a substitute for evidence, relying on the cases of Baba against INEC and Ogbo Ojeme against Selo. Citations are supplied. Also, Ogwebi against FBNPSC, that no pleading and evidence was laid in proof of the submission that only loyalists of board members were considered. CW1 admitted that workers, including himself, were promoted and that the defendant also did a general promotion for staff. The claimant is bound by its own evidence and cannot be allowed to deviate from same. On the claimant's submission, at paragraph 4.5 of the claimant's address, that the defendant mobilized attack, intimidated, and harassed members of the claimant when they embarked on a peaceful protest, it was replied that the allegation is a crime of conspiracy and assault, occasioning harm, which must be proved beyond reasonable doubt. Counsel referred to Magaji against APC and also Lead Securities Investment against Elizabeth. Citations are supplied. That the claimant failed to link the defendant with the attack or call any evidence to show anyone attacked at the defendant's instance, and the defendant cannot be held liable for the act of the police in maintaining peace. On the claimant's allegation that the defendant earmarked workers for transfer outside its mandate areas as punishment for engaging in union activities, it was replied that the claimant failed to show list or any evidence of workers listed for such transfers, that CW1 admitted under cross-examination that the defendant has power to transfer staff to other agencies in the state and that this had been done previously. With respect to the arguments, at paragraphs 4.1, 4.31, 4.32, and 4.36 of the claimant's address, that since Exhibit DW10 made no mention of the outstanding salaries between 5th of January 2009 and 11th of May 2011, the said entitlement is saved. It was replied that Exhibit DW10, which was accepted by the staff, clearly stated that the letter supersedes any previous letter. That in the case of Stoll against Ben Stoll, citation is supplied. The word supersede was defined as the verb to supersede, means to make void, annul, repeal by replacing. Counsel also referred to the Advanced Law Lexicon, 3rd edition, that the effect of Exhibit DW10, which was accepted by the workers, was to extinguish any right contrary to that in Exhibit DW10. On the claimant's submission, at paragraph 4.43 of the claimant's address, the promotion to higher office must be done within 2 years of being on a post. It was replied that nowhere in Exhibit CW001 is it provided that promotion must be done within 2 years of being on post, that the claimant cannot read into Exhibit CW001 what is not there, relying on the case of Ogundana and Sons Trading Company, Nigeria Limited, and another against First Bank. Citation is supplied. On the claimant's contention that Exhibit DW16 is a bill and not a law, it was implied that the said exhibit is a law and not a bill because it was assented to by the governor of Delta State on the 18th of August 2015. The court was urged to dismiss the suit. Now, court's decision. I have carefully considered the pleadings, evidence, and submissions of both learned counsel to the parties, and I am of the considered view that since the issues crafted by both parties are identical, the court shall determine the suit on the basis of the claimant's issue, which is whether, having regard to the state of the pleadings and the evidence laid in this suit, the claimant has sufficiently proved his case to be entitled to the reliefs claimed in this suit. It is opposite to start from the premise that the onus or burden of proof in this suit is on the claimant, who asserts to establish his claims on the preponderance of evidence or balance of probabilities. In the circumstance of this case, where reliefs 1 to 4, where reliefs 1 to 9 are declaratory reliefs, the claimant can only succeed on the strength of his case and not to rely or take advantage of any weakness in the case of the defendants. The law is that declaratory reliefs are not granted as a matter of course, but must be proved through cogent and verifiable evidence. They are also not ordinarily granted in the face of an admission or default of pleadings on the part of the defendant. See sections 131 to 134 of the Evidence Act, and the cases of Yusuf, Shaibu, and others against Nigerian Bottling Company PLC, Coca-Cola, and also First Bank PLC against Ibrahim Sani Momo. Citations are supplied. See also Charles Organ against Nigerian Liquefied Natural Gas. In the case of Attorney General of the Federation against Attorney General of Abia State and others, citation is supplied. The Supreme Court held thus with respect to proof of declaratory reliefs, and I quote, "The relief sought by the plaintiff being declaratory, the law requires that the plaintiff, by way of credible, cogent, and sufficient evidence, must prove his entitlement to the reliefs which cannot and should not be granted, even on admission by the defendants. In law, the absence of a defense or weakness of such a defense will not entitle the plaintiff to the grant of the declaratory relief sought, since he is to succeed only on the strength of his case." End of quote. In the bid to establish his claims before the court, the claimant subpoenaed one Gabriel, a young woman, the defendant's deputy director and director of legal services, who produced the document listed as number 17 on the subpoena dated 15th of July 2019, and the said circular dated 9th of August 2018 was admitted as Exhibit CW 1A. The claimant's second witness, Mr. Solomon Obamaga, testified on the 4th of February 2015 by identifying and adopting his witness statement on oath filed on the 22nd of November 2022, and the additional deposition he made on the 7th of March 2023. He then tendered Exhibit CW001 to CW31. Some of the salient answers elicited from the witness during his cross-examination by the defendant's counsel, E. Otrofanowe, on the 4th of February 2025 and 17th of October 2025, are that he is on grade level 05 and that he is aware that the defendant has a condition of service which is binding on both the claimant and the defendant. He refuted the insinuation that the defendant has the right to vary the terms in Exhibit CW001. He affirmed that the defendant was set up to manage the 13% derivation fund accruing to the oil producing areas in Delta State, and has a board charged with the management of the resources which are applied in various development projects of the state, including public buildings and payment of salaries. He affirmed that Exhibit CW26 was addressed to the MD of the defendant, and that there is no acknowledgement of service on the defendant. That one of the grounds of the suit is that the defendant has refused to promote the staff, and that while junior staff are to be promoted after 2 years, the senior staff are to be promoted after 3 years. But he affirmed that promotion is based on vacancies at the passing of promotion interview, that after 14 years, he was promoted in 2024, after he was last promoted in 2010, and that the instant suit was instituted before the management started promoting 20% of the workforce. He, however, affirmed that the union filed for an injunction in the suit to restrain the defendant from promoting anyone, but he is not aware if the application for injunction was refused by the court. That while the number of staff were interviewed, passed, and have been promoted while the suit is in court, but the promotion was lopsided because of the 5 ethnic nationalities in the commission. Some got higher number than others. that promotion is a continuous exercise. He affirmed that Exhibit CW25 has no signature, and also affirmed that under Exhibit CW001, the defendant has the right to transfer staff to other organizations or agencies of Delta State government, and that many staff have earlier been transferred to the Ministries of Justice and Education, that their union came to the court against the transfer because of the victimization of the union members, and that those who were transferred refused to go on transfer because the court asked the parties to maintain status quo. He also affirmed that it is for his employer to give him work and not for him to choose the work he wants to do. The witness informed the court that he is not one of those allegedly assaulted by the police, and that those assaulted are alive and still in the employment of the defendant, that the staff affected were invited to face the disciplinary panel, and they went to the panel. He affirmed that there is a provision for punishment in the Constitutional Service, and that punishment includes suspension with or without pay, that he is not aware of any circular that a worker in need of medical treatment should first report to the medical center before a referral is made to another hospital. He affirmed that the defendant's office is in a high security area where there are the Navy, the NNPC, and banks, and that the place is manned by military, the police, and other security agencies, that they did not refuse to go on transfer because the transfer came when the issues were already before the court. He affirmed that the commission's revenue is managed by the board, and that it is for both the staff and the development of the state, that he has seen the law establishing the defendant, and he pays his dues to the claimant, but he does not have any proof of the payment, that they are entitled to the claims before the court. The defendant on her part called one Akparobi Precious or Galomenu, who testified on the 17th of October, 2025. The witness identified and adopted her witness statement on oath, filed on the 17th of January 2023, and then tendered exhibits DW1 to DW16. Some of the high points of the answers elicited from the witness during her cross-examination by the claimant's counsel, Adejo Abba, on the 17th of October 2025, are that she was employed on the 31st of January 2008, but that she cannot recall when she was on grade level 12, that she can also not recall when she promoted herself to grade level 14, and it was reversed to grade level 12. That from paragraph 3.6.1 of exhibit CW001, which she read, it is correct that the defendant paid end-of-year bonus in 2014, and that exhibit CW027 is the board resolution for the payment. She affirmed that the defendant has not paid end-of-year bonus in 2016 to 2024, that she is neither the governor nor the government, and she is not in the finance department of the defendant to know whether 13% oil derivation fund is being remitted to the defendant, that she knew of the paucity of funds in the defendant from the circular from the management, and she refuted the insinuation that the decision to stop the payment of end-of-year bonus was taken by the management and not the board. She affirmed that exhibit DW8 is a circular by the management stopping end-of-year bonus, and that the management is part of the board, that the head of the management is the MD/CEO, while the chairman of the board is the head of the board. And she gave the name of the MD as Chief Festus Ochonogo and the name of the board chairman as Chief John Nani, that the head of the management and the head of the board are not the same, because the board comprises of the chairman, the MD, 4 executive directors, 9 ethnic representatives, while the management comprises of the MD and the 4 executive directors, that not all the members of the board are members of the executive management, and the executive management implements the decisions of the board, that she does not have access to the board resolution with respect to exhibit DW9. I have seen that the claimant, as a trade union, is alleging that the defendant is in breach of the provisions of the conditions of service relating to payment of end-of-year bonus, 13th month, to members of the claimant, deduction in the salaries of the members of the claimant, failure to provide medical benefits members of the claimant and failure to promote members of the claimant, amongst other allegations as contained in the claimant's pleadings. The defendant has strenuously made the point that the failure of the defendant, sorry, I take that again. The defendant has strenuously made the point that the failure of the claimant to plead and produce the letters of employment of its members is fatal to the case because the letter of employment is the bedrock or primary document required to prove the case. While I agree with the defendant that in cases involving termination of employment, the production of the letter of employment is indispensable. The point must, however, be that the case of the claimant is not one involving allegation of wrongful termination of employment. The case is basically founded on the terms and conditions in Exhibit CW001. The defendant is not denying employing the members of the claimant and has even gone ahead to tender Exhibits DW3 to DW5, which are the employment letters of some members of the claimant. I therefore hold on this point that since the members of the claimant are still in the service of the defendant and the suit is founded on the conditions of service, Exhibit CW001, the failure of the claimant to tender any letter of employment of its members is not fatal to the suit. With respect to the reliefs in the suit, reliefs 1 and 2 are for declarations that the employment of the claimant's members in the defendant is regulated by the defendant's Exhibit CW001, and also that the defendant is bound by the terms of Exhibit CW001. There is no doubt that Exhibit CW001 is the defendant's condition of service 2012, and since the members of the claimant are employees of the defendant, I hold the considered view that their employments are regulated by Exhibit CW001, which is binding on both the employees and the employer, the defendant. See the case of Mr. Yenagoa, Richard Ovevie, and others against Data Steel Company Limited. Citation is supplied. And also Mala Mohammed M. Al-Hassan against Ahmadu Bello University Zaria and others. Citation is also supplied, where the Court of Appeal held as follows, and I quote, "The parties are bound by the terms and conditions of the contract of employment between them, and since the appellant's employment has statutory protection, he can only be removed in the way and manner directed by Statute 8.5 of the first schedule to the Ahmadu Bello University Transitional Provisions Act and Section 3F of the regulations made thereunder." End of quote. Reliefs 1 and 2 are therefore granted.
As court pleases.
Relief 3 is for a declaration that the refusal of the defendant to grant audience to the claimant to address issues of the workers' welfare constitute unfair labor practice and offense international best practice. The contention of the claimant is that despite sending Exhibits CW009, CW10, CW14, CW22, and CW23 to the defendant, seeking to have audience with the defendant failed to give the claimant's members audience with a view to discussing the issues that led to the institution of the instance suit. While I have seen that this request for audience with the defendant were received by the defendant in 2017 and 2018, the claimant has, however, not shown this court how the defendant's refusal to meet with them simpliciter constitute unfair labor practice and offensive to international best practices. No international best practice has been referred to by the claimant. If anything, it is the refusal that led to the issuance of Exhibit CW007, the pre-action notice, and the subsequent institution of the instance suit in court. In any case, the claimant's Exhibit CW26 has no acknowledgement indicating receipt by the defendant to indicate when the document was received by the defendant. Relief 3, therefore, fails, and same is hereby refused.
As court pleases.
For Relief 4, which is related to Reliefs 10 and 11, relating to alleged victimization of the members of the claimant through issuance of queries, transfers, and suspension on ground of their union activities, let me state straight away that the onus of proof of the alleged acts of victimization on grounds of trade union activities is on the claimant. The claimant did not call any of its members that was either queried, suspended, transferred, or otherwise discriminated against to testify in this suit. Even when CW2, Mr. Solomon Obomagwa, admitted during his cross-examination that the persons allegedly assaulted are alive and in the employment of the defendant. No letter of query, transfer, or suspension was produced by the claimant to substantiate the allegation. The allegation of victimization of employees is not one that can be proved on the strength of oral evidence of the witness alone, more so that none of the employees that were allegedly victimized was called to give evidence in the suit. Since the defendant, as an employer, has the powers to transfer employees under its employment, the claimants must prove that the transfer was vindictive for the court to intervene. Having failed to establish the allegation of victimization, I hold that reliefs 4, 10, and 11 fail, and are hereby refused.
Score, please.
For relief 5, relating to the 2016, 2017, 2018, 2019, 2020, and 2021 end-of-year bonus, I have seen that the relief is predicated on clause 3.6.1 of SCB CW001. The said provision states as follows, and I quote, "Every staff who works in the commission for 12 months in any calendar year is entitled to end-of-year allowance of 1 month's salary, except those with disciplinary cases. However, new staff engaged within the year of payment shall be eligible to be paid on pro rata basis, provided they will have spent at least 6 months by the end of the calendar year. Also, members of staff who proceed on course lasting for more than 6 months, or on voluntary retirement, or who leave the services of the commission in any manner other than by termination, dismissal, or compulsory retirement, shall be able to be paid on pro rata basis, provided that they will have served for at least 6 months during the year of payment." End of quote. While the claimant's contention is that the defendant paid end-of-year allowance in 2014 and 2015 and has failed to pay for 2016 to date. The defendant contends that while it is true that such payments were made prior to 2016 by SCB DW8, the defendant stopped the payment of end-of-year bonus with effect from 2016. I have pored over SCB DW8 and seen that same is a circular issued by the defendant to all the staff of the defendant dated 16th of November 2016, notifying the staff of the decision of the management to discontinue the payment of end-of-year bonus effective 2016 on the grounds that same is not contained in the rules and regulations governing employees in the civil and public service of the Federation, and also a privilege, not a right. While it would seem that the provision of clause 3.6.1 of SCB CW001 on the payment of 13 months to members of the claimant is a binding provision that should be complied with, particularly that such payments were made in the past. I cannot, however, fathom why SCB DW8 issued by the defendant in 2016 was not challenged by the claimant until when the instance suit was instituted in 2022. The said provision does not affect only members of the claimant, but all other employees of the defendant. The claimant is alleging that the defendant has no powers to unilaterally amend SCB CW001 by the issuance of SCB DW8, but took no steps to challenge the issuance of SCB DW8 from when it was issued on the 16th of November 2016, having failed to challenge SCB DW8 when it was issued in 2016, stopping the payment of 13 months to all the employees of the defendant, including members of the claimant. I hold on this relief that the claimant failed to prove same, and the said relief 5 is hereby refused. For relief 6 and 7, relating to the payment of the outstanding 30% of the salaries of members of the claimant from July 2009 to April 2018, I have seen from SCB CW28 that the board of the defendant reduce the monthly salaries of the staff by 30% for the months of July, August, and September 2009. There is no indication that the deducted 30% of the monthly salaries have been paid by the defendant to the workers. The defendant has tried to justify the reduction in staff salaries on the alleged paucity of funds and the fact that while by the establishment guidelines, 300 staff were to be employed, over 4,000 were eventually employed. Since the claimant's members worked for the months, their salaries were paid less 30%. I hold a considered view that they are entitled to the outstanding 30% of their monthly salaries. The issuance of subsequent letters of employment, exhibits DW3, DW5, DW7, DW10, DW12, and DW15, dated May 2011, to them cannot override or supersede whatever rights that had accrued prior to 2011. Reliefs 6 and 7 are hereby granted.
Let's call please.
On relief 8, for the defendant to implement the medical benefit package, I have seen that the relief is hinged as 3.4.1 of Exhibit CW001. The said provision enjoins the defendant to, in addition to having a staff clinic at the Commission's headquarters, take responsibility for the cost of medical treatment received in government hospitals and from clinics approved or nominated by the Commission. The claimant has not called any employee to testify that the defendant failed to honor any application for payment of medical services. Exhibits DW1 and DW11 tendered by the defendant are evidence of approval and payment for medical services rendered to some of the members of the claimant. Suffice it to add that Exhibit CW001 does not provide for payment of medical allowance, but for the employees to access medical care at the defendant's staff clinic or any government-owned hospitals and clinics approved or nominated by the defendant. This is clearly what the defendant's Exhibit DW9, particularly the annexed circular dated 10th of September 2010, aims at achieving. Relief 8 is therefore refused.
Let's call please.
Relief 9 is for an order of court compelling the defendant to promote members of the claimant in line with Chapter 2, Clause 2.15 of Exhibit CW001. Let me state on this relief that since promotion in any organization is not a right but a privilege, the claimant cannot urge the court to make an order for automatic promotion of its members. Clause 2.15 of Exhibit CW001 clearly spells out the requirements that must be met for an employee to be promoted to the next rank or grade level. Such requirements are performance, existence of vacancy, experience, and length of service, maturity, minimum of 2 years on the post for salary grade level 1 to 6, 3 years on the post for salary grade level 7 to 14, and 4 years on the post for salary grade level 15 to 17. In any case, the claimant's witness testified that he was promoted in 2024. On this, see the case of Sylvester Wonye against Federal Airports Authority of Nigeria. Citation is supplied, where the appellate court held as follows, and I quote, "Promotion from one level or position in an organization to another is not a right but a privilege which is earned. An employer cannot be compelled to promote his employee, no matter the good opinion the employee may have of himself." End of quote. See also Joseph Hamman Abenga against Benue State Judicial Service Commission and another. Citation is supplied. Relief 9 is therefore refused. Relief 13 is for an order of court directing the defendant to deduct check-off dues of 3% from monthly basis salary of the members of the claimant and remit same to the claimant. It is on record that from Exhibit CW30, CW2, CW3, CW4, the defendant requested The claimant's unit at the defendant's office to furnish the defendant with an updated list of its members for the process of payment of check-off dues, and the claimant made several appeals to the defendant for the said deduction of the check-off dues via Exhibit CW11, CW12, and CW17 as far back as 2017, all to no avail. Having recognized the claimant in the defendant as evidence in Exhibit CW005, the defendant has no justification for the failure to deduct check-off dues from the monthly salaries of members of the claimant and remit same to the claimant for the day-to-day running of the union. The right to belong to a trade union of one's choice is constitutionally guaranteed under Section 40 of the Constitution as amended. Section 16A, as amended by Section 3 of the Trade Unions Amendment Act 2005, mandates the defendant as an employer to make deductions from the wages of every worker is a member of any of the trade unions and remit such deductions to the registered office of the trade union within a reasonable period. The members of the claimant are junior staff, hence their membership of a trade union is automatic. The membership is assumed, hence while they opt in automatically, they can only opt out in writing, unlike senior staff that must opt in writing to be members of a trade union. So for junior staff, like members of the claimant, they are deemed to be members of the trade union until they decide to write individually to opt out of the union. Their recognition is automatic, and the deduction of check-off dues by the defendant is compulsory. See the case of Nest Oil PLC against Nopeng, citation is supplied. In the circumstance, I find merit in relief 12, and same is hereby granted. Having found merit in some of the reliefs in the suit and granted same, and since cause follows event, I find merit in relief 13 for the cost of 1 million naira. Sorry, I find merit in relief 13, and the cost of 1 million naira is hereby awarded in favor of the claimant. If the defendant had paid the claimant's members the outstanding 30% of their monthly salaries and also deducted and remitted check-off dues to the claimant, this suit would have been avoided. In the final result, and for the reasons given above, the loan issue is resolved in favor of the claimant, and I hope that the claimant's case succeeds in part only with respect to release 1, 2, 6, 7, and 13. For the avoidance of doubt, the court hereby declares and orders as follows. 1, it is hereby declared that the employment of the claimant's members in the defendants is regulated by the Delta State Oil Producing Areas Development Commission, the Sopade Staff Condition of Service 2012. 2, it is hereby declared that the defendant is bound by the terms of the Delta State Oil Producing Areas Development Commission, the Sopade Staff Condition of Service 2012. 3, the defendant is hereby ordered to pay arrears of 30% of salaries for members of the claimant who were owed since July 2009 to April 2018 forthwith. 4, an order of perpetual injunction is hereby made restraining the defendant from further deducting and withholding 30% of salaries of members of the claimant from May 2018 as being contrary to the terms of their contract and extant labor laws in Nigeria. 5, the defendant is hereby ordered to deduct check-off dues of 3% from monthly basic salary of its staff that are members of the claimant and remit same forthwith to the claimant. 6, the cost of the suit is assessed as 1 million naira, which is to be paid to the claimant by the defendant. 7, the terms of this judgment shall be complied with within 30 days from today, failing which it shall attract interest at 10% per annum until it is fully liquidated. The judgment is entered accordingly.
Let's go, please. We want to thank my Lord for a well-considered judgment. We are so grateful and pray that the good Lord will continue to enrich my Lord with wisdom to continue to do justice. Thank you, my Lord.
Yes, sir. Thank you. You have copies from tomorrow.
As please.
All right. Thank you.
Thank you, my Lord.
We want to thank my Lord for the well-considered judgment. It was a challenging fight, and I want to thank my Lord that after all of it, my Lord came up with a very sound judgment. It's a prayer that our Lord will go further and further in the judiciary. And we'll certainly take steps to collect the judgment tomorrow. Thank you, my Lord.
Yes, sir. Yes, sir. Thank you.
You can show them.
Come.